Welcome, I'm Peter Coronius, and with me today is Patrick Fair. So thank you, Patrick, for joining us.
My pleasure, Peter.
And welcome, Cyan members. Patrick, it's been a fairly tumultuous 12 months. We've had COVID, the pandemic, on us. But the government hasn't been sort of caught napping here. They've been busily legislating in the background or conducting reviews. And recently you've written a very excellent summary of the main legislative instruments that are either have been recently reformed or in the process of reform. I thought today we'd just cover a few of those and get some high-level points from you on concerns you've got or anything that you think might be of interest to our colleagues, not just in Australia, but also internationally.
Certainly, Peter. It's been an extremely demanding time for people in regulatory affairs, with the government throwing out reports and issues, sometimes acting, sometimes not acting, and pushing through legislation, at breakneck speed that have made significant changes to the national framework for protecting our cybersecurity systems.
Mm. Yeah. And I think the other point to note just at the outset is that some of these laws are not without controversy. There are definitely implications here that I think we might draw out a little bit, if you can, for us, for civil society and individual freedoms, and also, I guess, the commercial operations of companies in Australia and multinationals, even, for whom this is a bit of a uncharted territory and may have implications for the global business.
I think that's right. I think the red tape element of some of the requirements is pretty heavy-handed, and there'll be a real question as to whether the new laws are going to be a dead letter, rarely used, and not actually implemented by, in the case of national security infrastructure anyway, the making of rules with a large cross-industry impact. But that's certainly the potential. And the other thing is that some of the powers that are being introduced are being introduced in the old framework with the old expectations as if they were a paper warrant. But the powers relate to electronic systems and devices, and therefore the implications for what law enforcement might be able to do with the powers, and for the privacy and political implications for the potential targets is quite significantly different from what it would have been if it had been just a paper power.
So you're suggesting that because they're attempting to grapple with the digital dimension, that the previous, the legacy paper-based warrant system may not translate well in terms of checks and balances?
That's right, yeah.
Right, I see. Okay, well, let's turn to a number of these. We're not going to cover all of them today, but I would direct our members and those that are watching this video to your excellent summary, which we will attach to this video, so people will be able to go and look at in a little bit more depth about some of the points that you're raising today. Let's start with the new framework for the security of critical infrastructure. So as your summary reads, and I might need to magnify that a bit, we've got the Security of Critical Infrastructure Act of 2018, which is abbreviated to SOCIA, is that how you say it? Requiring the owners of certain nominated ports, electricity, water and gas infrastructure of scale, and other infrastructure nominated by the Minister to be placed on a secret register and required to report ownership and operational details. So that's the first. Now that's a new obligation, is it, in this bill?
No, that became law in 2018, and when I say of scale, the ports were actually named, but in the case of the other pieces of infrastructure, the test is something like they serve 100,000, population of 100,000 in terms of their scale. Mm-hmm. And there's a special measure for electricity generators because, as you imagine, they don't serve a particular area, the electricity is shared. And the two things that the government were interested in is, who owns you, and tracking that back to see if there's a national foreign interest owning it there.
Right.
And also, have you got your control systems set up and operations set up so that it creates a risk to Australia. For example, if a power station was managed offshore in a foreign jurisdiction, or key gates and control systems were accessible offshore. So that's what the Act currently says,
right.
And what the update talks about are the
amendments.
proposed amendments to the Act, which really change its character quite significantly.
So let's just park that for a second and just go back to the original Act. So clearly what the government seems to have been trying to address here is the nation-state threat. Primarily, if you're looking at the potential for foreign ownership and control of critical information or critical infrastructure. In this case, it seems to be largely talking about physical infrastructure, but it wouldn't preclude something like a telecommunications network either, would it?
No, under the bill as it was, under the Act as it is law now, telecommunications isn't mentioned specifically because there's a telecommunications security framework which is in the Telecommunications Act, directed at national security issues.
Mm-hmm.
That's not to say, though, that some things in the communications framework might not be nominated by the Minister as critical infrastructure. For example, under the existing scheme, if the Minister wanted to, he could pick a large data centre or a electronic marketplace or some other system that was critical to the operation of government and declare it critical infrastructure, and then those rules would apply.
So in other words, you're saying there's sufficient scope within the current Act that things that would not normally fall within the ambit of the current regulatory environment under telco could be brought in under this regime effectively by a declaration.
That's right, but the requirements are only those reporting requirements. I should maybe sort of give you the context. If you have to do a filing if you get nominated, and then you're under an obligation to update that filing within 30 days if anything changes.
Right.
And the Minister, meanwhile, has a power to direct you to do any act or thing which he judges as being adverse to national security. So if you report that you've had a change of ownership, and then the Minister might come back and say, well, I want that transaction cancelled or reversed. Or if you report that you're using a at-risk outsourced service provider that the government has on a blacklist, then they can come back to you and say, no, you're not doing that. So the framework is designed to require basically large asset owners and operators to be thinking about national security and the government's potential to intervene in their operations and behaviour in the interests of national security, and thereby, stay out of the reach of the Minister and his powers.
Interesting. And so in terms of this, all this discussion so far is around the ownership and control of the infrastructure, as in the entity are we talking about, or specific assets within the entity?
It's the entity that owns the assets.
Because there's a reason why I make that or sort that distinction. As you recall, under the recent Trump administration, there was a directive from the President to sequester incoming electricity generation infrastructure. Do you remember that they purloined this massive generator that was coming in from China, and they wouldn't allow the electricity provider to take collection of that because there was a fear that it had been compromised and it was going to be going on a network, and therefore it was introducing a vulnerability into a grid situation. Would this legislation as it currently stands, without the amendments, touch on a situation like that?
Without the amendments, it could if the operational report required being updated, and the Minister got that update and decided that there was a security risk, then the processes that are in the legislation now, which involve a consultation step and a sort of advisory step before the Minister can exercise his powers, that could be called into operation. But it wouldn't be, it isn't as direct as the, if it was a system of national significance under the amending legislation, then the powers are much wider and much more focused on the possibility of having the Australian Securities Directorate come in and examine the asset.
Right, but just to clarify that point, you're saying that an operational change of the nature that I described could be enough to trigger a ministerial intervention if they deemed that there was a security threat attached.
That's right. That's right. But you're talking about this very significant scale of infrastructure, and you'd first get the soft power sort of minister advisory, and then if you didn't like that, the minister can go away and get a ASIO to make a security assessment, and if that's adverse, then the minister has the power to direct you.
And could they seize the equipment under that power? Would that be one of the powers open to the minister, is to order the surrender of the equipment, or at least some assessment of it?
The power, as I recall in the legislation as it stands, is very broad. It's pretty much the minister can take such steps as he considers necessary in the circumstances.
Right.
So potentially that's doable, but it's not listed.
Not listed, but it's within the theoretical contemplation of the bill or the act as it currently stands. Great. I mean, why I went down that path just then was to really see whether there was much consistency between what's happened in the US and what could happen here under the legislation, because I think clearly what we're seeing within the cybersecurity community is that the supply chain vulnerability is becoming a huge vector for attack and infiltration of networks. And of course, as you rightly point out, we're talking about major infrastructure facilities here which would have an impact on the economy and presumably health and safety of the nation, things like that. So
that's right.
This is the direction that I guess cyber has been moving in respect. Well, we haven't really seen a kinetic attack in Australia against something non-digital up to this point, except one or two cases, which we could probably talk about later. Well, the main one you might recall was the Tech Bowden breach on the Maroochydore Shire Council water supply.
Yeah,
remember that back in about 2000, and it was a disgruntled contractor that had a beef with the council and decided he was going to hack the valve system that controlled the sewage flows and basically polluted the drinking water with 200,000 litres of sewage, and I think received a suspended jail sentence for that. But to my mind, that was really the only tangible evidence of an attack against physical infrastructure using a cyber sort of weapon. But this bill really moves us into that realm now, this act, that the government's thinking very clearly that this is something that we're going to see more of potentially, and they want to have the instruments in place.
I think that's the focus of the legislation as it stands now. I think as amended, the bill will have a much wider remit and go to things like protecting confidential information and protecting the valuable commercial information, generally maintaining a sort of a robust and resilient sort of economy at a much more iterative level.
So let's talk about those amendments. I hope you're still following this, so let's just recap. We're talking about a new framework for the security of critical infrastructure. So these are the major infrastructure facilities of the nation, the utilities and things associated with that. So let's look at the amendments now that are on the table, and they're now before the Parliamentary Committee.
The first thing that they've done is they've defined what could be a critical infrastructure asset quite broadly by naming sectors. And the purpose for naming the sectors seems to be that depending on which sector you're looking at, the party that is the responsible entity is the regulated party in that sector. So in the financial sector, it's deposit-taking institutions and other regulated financial entities. Over in telecommunications, it's carriers and carriage service providers. And then when they get to things that aren't fully regulated, they talk about features and scale. So food and health are included, the space industry is included. And so you read this act and you see this very broad definition but nothing gets activated unless the minister makes rules which include the asset in the obligations. And the making of the rules can determine whether the asset is included and also what obligations might apply to the asset. So it's just giving us scope to cover, almost all the Australian economy. You have to work hard to find something outside the sectors that I mentioned that's of any significance. And if the minister makes a rule about an asset, and it's not clear whether the minister will make a kind of omnibus rule, just saying every bank or every bank branch or and something like that, or whether there'll be well, we're going to pick this one and that market, so that's up for consultation.
Right.
But once you get picked, then the next thing is they can say, okay, now these obligations are going to apply to you, and the first is you have to have a plan, a cybersecurity strategy. So you need to document how you're securing your network, and then you have to do an annual report as to how you've performed, and also you pick up an obligation to report cyber incidents. And so this isn't like under the Privacy Act where you have to tell the people who've been compromised and explain how they can remediate the breach. This is just a report to the regulator saying I've had these breaches.
Yes.
And if the regulator, if they don't like the report that you give them annually, then they can ask you to put in an independent auditor and get the auditor give them a report about your infrastructure. So essentially, it's a way to force assets that are deemed to have a critical role in different parts of the industry across Australia to make sure that they're, in a professional way, thinking about cybersecurity and managing it.
Right.
But also, it has a kind of red tape element in that, what board of any competence in Australia of any significant asset hasn't already got some kind of a cyber security plan in place. So what they're really picking up is this obligation to report their breaches to the department, and also to do the annual filing. Right.
So let's take a hypothetical situation, assuming the bill went through in its present form. A company or an infrastructure owner, their system comes under a cyber attack. They may not be able to determine the source of the attack, but they can definitely tell that there are outages occurring that have been attributed through their own internal investigations to cyber. At what point does the reporting obligation trigger? Is it as soon as they've identified the attack itself, or do they have to provide details as to the nature of the attack and what the possible origin of the attack is? Where does their reporting begin and end in that kind of situation?
Look, that's a good question. I have to look at the provision in the Act and the precise obligation, but my recollection is that it's immediately, and it's not. I think the intention is that the details of all of that is going to be worked out.
Right, I see.
But the other thing to say is that that's the layer for the general economy. There's also a concept in the amending legislation of systems of national significance, and this is where an asset is thought to be critical in that there's an interdependence between that asset and other critical systems. And so if you because of that interdependency, you're particularly vulnerable or present a particular risk, then you can be deemed also by rules or a ministerial declaration to be a system of national significance.
Right.
And if you're deemed that, then you have the obligations which we've already mentioned. I should say that the ones that are in the Act now also apply. So reporting ownership, reporting systems, and then having your cyber plan, and then reporting breaches, and then doing an annual report. But now you also must participate in a sort of a war game regarding a cybersecurity incident if the government decides. So there'll be a proxy incident, and you'll have to participate and work out how you'd respond, and that will be monitored and reported on. And there are other powers applying to systems of national significance, including if they want to, the Australian Signals Directorate can come in and look at your systems and make recommendations and possibly take control of them.
This is before an attack has occurred, you're saying? Once they've declared it to be a system of national significance? They can do all these other things.
When considered, reasonable and necessary.
Right, so it's an elevation beyond just the national, the owners of certain nominated
critical infrastructure assets.
But if it goes to the next step, which is a asset of national significance, you're saying additional obligations can come in that would permit a more interventionist hand of government, digging around and testing, trying to break things, and
also requiring you to put your cybersecurity team and some of your systems and people into a simulated event to see how you would handle it and what who you should talk to and what you need to do. One last point about that that's quite interesting, of course, with a national security framework already in the telecommunications legislation. The first thing that the telecommunications industry said about this is, are we included and why? And the government politely described it as parallel. i.e. yes, you are included.
Right.
And so of course the telecommunication industry will be saying, well, look, can you decide? Do we really have to have one framework over here in the Telecommunications Act and this whole separate framework with potential overlap?
Because they are not exactly parallel. I'm somewhat familiar with the telecommunications regulatory environment, clearly not as much as you, but it seems to me that there would be significant overlap for some of these new obligations that are present in this bill, and even in the act that underlies it.
That's right.
Goes beyond what they have to do already.
Certainly the power of the minister to review and reject is already legislated in relation to changes to telecommunications infrastructure that might be adverse to security.
Right. So let's just wrap up on this point. In a moment we're going to look at another piece of legislation, which is the Surveillance Legislation Amendment Identify and Disrupt Bill. But we might just bring this segment to a close now, just to wrap up, to say that I've been talking with Patrick Fair on the new framework for the security of critical infrastructure and on the 2020 amendments to the 2018 legislation that had passed back then. And this act will touch upon primarily the owners of major infrastructure assets in Australia.